Hi, I'm Joel Hamner with the law firm McCutcheon Hamner. In this series of videos, we've been talking about claiming Social Security disability benefits. Now, I've talked to you in these previous videos about what is Social Security supplemental income, what is SSDI, and what the process is. So let's talk about what judges look for and what are the qualifying factors for a person to claim Social Security disability income. So I talked to you previously a little bit about the methodology. Now let's assume that a person is no longer capable of working. They've met their date last insured, so they can qualify for Social Security disability income. They've made their initial filing and they've been turned down. So you've come to us and I've helped you file your appeal, and my staff and I are working with you toward a hearing before the administrative law judge. And that judge is going to hear your case along with a vocational expert that we talked about previously, and he's going to make a decision as to whether or not he believes that you are totally incapable of working in the national economy. So what factors does that judge look at? These are not random factors, and they're not random elements. There's a portion of the law called the Code of Federal Regulations, or the CFR, and that CFR dictates or establishes what each administrative law judge is to look at in making a decision as to whether or not a person is totally disabled. One of the very first things we look at is their age. Age is a very important factor in the ability to claim Social Security disability benefits. Over the age of 50 and over the age of 55 is a huge issue, and here's why. Let's say you're 56 years old and you've been a block mason all your life. And let's say that you've injured your back and there's no way you can return to laying block or brick. In that case, there is a presumption by the Social Security Administration that if a person is over the age of 55 and they are no longer physically capable of doing the job that they have done for the majority of their life, then they are disabled, because the Social Security Administration recognizes that over the age of 55, the likelihood of an individual being retrained for another occupation is not likely. So if you cannot go back to doing the job you were doing at 55, then under the regulations, you're totally disabled by Social Security Administration. Now let's talk about a person who is 50 years old and not 55. Let's say they're 52, 53. Well, the presumption is there that if they can't go back to work, that they are disabled, but it's rebuttable. And what I mean by that is this. Let's say that you work as a block mason again, and so you have a very heavy job and you have injured your back and you're no longer able to lift more than, say, 10 pounds. But let's say in your years before you were a block mason, you worked as a store manager, or you were a computer programmer and you just didn't like working in an office and you wanted to be outside. Well, now the court's going to look at it and they're going to say, okay, now he's 50 years old, so there's a presumption that he's probably not going to be able to be retrained for anything, but has he developed transferable job skills that could keep him employed? So they're going to say, well, we agree, he can't go back to being a block mason. But did he learn enough back here as a computer programmer that he can be capable of being employed in the national economy? So that becomes rebuttable. So your attorney has to step up and prove that, hey, judge, yes, he was a computer programmer, but he did that in the 70s and those skills are no longer valid. Or, judge, due to the pain and the medication he takes due to the failed back surgery, he can't focus. He can't focus on an item long enough to be a computer programmer again. That's why it's so important to have a good attorney who understands the regulations. Now, for people under the age of 50, I will tell you that it is very difficult to qualify for Social Security disability. Now, it's not impossible, and I don't want you to misunderstand me, but it is very difficult in the sense that there are certain things that you better have and you better be doing and you better have your attorney focused on helping you obtain a decision for you in your favor. Once again, there's a difference between the age of 40 and 45 and 45 and 50. So let's say you're 45 years old. One of the biggest issues we have is people not maintaining adequate health information. So let's say you're between 45 and 50 and you've had an injury or an illness and you're no longer capable of working. Well, the presumption is that you can be retrained to do something between the ages of 45 and 50. So it's so important that you have continual medical treatment from a physician who I can take a statement from, who can say in their professional medical opinion that you are no longer capable of working, and here's why. Because an administrative law judge is going to rely heavily upon your medical evidence. Realizing that between 45 and 50, the likelihood is under the CFR, the Code of Federal Regulations, the law says you can be retrained to do something. So it's so important that you have a doctor who can say, you know, I understand they're 45 or 46 or 47 years old, but looking at their illness, looking at their injury, they're no longer capable of working, and here's why, and let that physician define the problems. One of the biggest issues I run into representing people for Social Security disability is they come to me, and I know they're disabled, but they haven't had any medical treatment in over a year, or they haven't had medical treatment in 2 years. And I understand our healthcare system as it is, trust me. You know, people come to me all the time and say, Mr. Hamner, we don't have health insurance, or we can't afford to go to a doctor. And I feel for those people because I see day in and day out the cost of medical care in this country. And I know how atrocious it can get. But the problem is for a person under the age of 50, and even for those over 50, if I can't create a thorough medical record that shows consistent problems and consistent complaints so that I can go to that doctor and get that statement from them, it's almost impossible to qualify that individual.